Welcome to the Upper Brand, the show where we unpack the biggest stories in trademarks, branding, and the laws shaping how products show up in the marketplace. I'm Rich Assmus, a partner in Mayer Brown's intellectual property, brand management, and litigation practice. With me today, as always, is my colleague and co host, Kristine Young. Kristine, good to talk to you again.
Always good to be here, Rich. So today's case is one that IP lawyers and brand managers have been watching closely for a while. Illinois Tamale Company versus LC Trademark Incorporated. It's a Seventh Circuit decision about the protectability of the pizza puff mark and whether Little Caesars Crazy Puffs creates a likelihood of confusion. The opinion touches on genericness, classic fair use, and how courts assess similarity when a house brand family, here the crazy marks, does a lot of the work.
So, we're going to walk through the backstory, tell you what happened in the district court, what the Seventh Circuit decided, and give you some practical lessons for in house teams, marketers, and litigators who manage descriptive marks and go to market naming strategies. It's appropriate we're recording this one over the lunch hour. So, Kristine, can you set the stage for us?
Yeah, so I guess initial question, what are pizza puffs and what are crazy puffs? The Illinois Tamale Company, many people know them as Il Taco, has been selling its pizza puff product since 1976. These pizza puffs are flour tortillas stuffed with pizza fillings that can either be fried or baked. The Illinois Tamale Company has owned the registrations for pizza puff since 2009 and the registration for puff since 2022. It also uses a portfolio of puff formative marks for various products. They have marks like Euro Puff, spinach and cheese pizza puffs, bacon breakfast puff, and so on.
Yep, this is definitely already getting me hungry. So, on the other side, in 2024, Little Caesars, the pizza chain probably many people know, launched their Crazy Puffs as part of its broad Crazy family. They have crazy bread, crazy sauce, and so on. Little Caesars even received a registration for Crazy Puffs on the principal register at the USPTO in 2024. The examiner on that application found no likelihood of confusion with prior marks, including the pizza puff mark that the Illinois Tamale Company owned.
So, Rich, can you explain what crazy puffs are for our listeners who have never eaten at Little Caesars?
Yeah, so Crazy Puffs are small baked pizza dough cups, and they're filled with pizza toppings and covered with cheese. They're basically stuffed pizza muffins.
Sounds delicious. And from a marketing perspective, the naming strategy, Crazy Puffs, tied the product back to Little Caesars' established brand architecture. But from a trademark perspective, the use of puff opened up Little Caesars to challenges from the Illinois Tamale Company.
Yeah, so the tamale company took a look at this, and the first thing they did in April of 2024 was send a cease and desist letter to Little Caesars, claiming that the Little Caesars use of crazy puffs and puffs alone was infringing its right in the pizza puff mark. As you might have guessed, Little Caesars disputed these allegations and continued to use the marks. And next step was that the tamale company actually filed a complaint against Little Caesars in July of 2024, asserting trademark infringement, false designation of origin, unfair competition, and state deceptive trade practices claims, all the things you typically see from a trademark plaintiff. And in particular, they allege that Little Caesars' use of crazy puffs and the phrase for handheld pizza puffs infringed the tamale company's rights in pizza puff and puffs. And they moved for a preliminary injunction to stop Little Caesars from using Crazy Puff, Pizza Puff, and Puff.
In ruling on the preliminary injunction, the district court split the baby. It enjoined Little Caesars from using Pizza Puff, but allowed its continued use of Crazy Puffs and Puff. And as you can imagine, both sides appealed. That set up two key questions at the Seventh Circuit. First, is pizza puff protectable as a trademark or a source identifier, or is it primarily understood by consumers as a generic term? Second, the question was, is there a likelihood of confusion between Little Caesars Crazy Puffs mark and the Illinois Tamale Company's pizza puff or puff marks? That's the ultimate question in any infringement analysis.
Great. So let's start with the protectability of Pizza Puff. What did the Seventh Circuit have to say about that?
Well, so the court reversed the injunction that had blocked Little Caesars' use of pizza puff and held that the Illinois Tamale Company had not shown a likelihood of success in proving the mark was protectable.
Yeah, so to succeed on that preliminary injunction, the movement was going to need to show that it was highly likely to win in its claim. And here, the tamale company sued Little Caesars for trademark infringement, among other things, and that therefore they had to prove it was likely to win on that claim in order for the court to grant the injunction. And importantly, the plaintiff also must show that it owned a valid and protectable trademark to be successful in that action. And the generic trademark, in other words, if Pizza Puff was just a way to describe a particular type of pizza product, that's not going to be protectable.
So, with that in mind, the Seventh Circuit emphasized the correct test for genericness, which is the primary significance of the term to the relevant public. Unfortunately for Illinois Tamale Company, the district court had applied the wrong test for genericness when it held that Pizza Puff was protectable because other brands selling similar goods were able to compete without using the mark.
And in applying that correct primary significance test, the Seventh Circuit concluded that Little Caesars had provided extensive evidence that consumers predominantly understand pizza puff as a generic term. There was consumer survey evidence that indicated more than 80% of relevant consumers viewed pizza puff as a common term rather than a brand. There were dictionary style definitions showing generic usage, as well as USPTO records where third parties had used Pizza Puff descriptively in applications and registrations. The Seventh Circuit panel explained that this was enough to overcome the presumption of validity and protectability granted to the registered trademark owner here. And they further held that the district court had misapplied the law by discounting the survey evidence and focusing instead on whether competitors could use other names to compete.
Exactly. The district court's rationale, essentially other brands could and do compete without saying Pizza Puff, is not the genericness inquiry. The question is how consumers primarily perceive the term. And here, the survey results and marketplace uses were persuasive.
So that holding really doomed the decision for the tamale company on their pizza puff mark. But the Seventh Circuit also turned to the crazy puffs mark. And that panel, Seventh Circuit panel, affirmed the district court's refusal to enjoin Little Caesars' use of Crazy Puffs and Puff. They found that there was no likelihood of confusion with either the tamale company's Pizza Puff or Puff marks. And there were two themes that dominated in this decision. First, the marks need to be evaluated as a whole and not dissected into their constituent parts. In addition, the Seventh Circuit focused on the house brand's strong role in signaling the source of the Crazy Puff product.
Yeah, and first the court found the commercial impressions were distinct. So Pizza Puff describes what's inside, which is pizza ingredients. Crazy Puffs leverages the crazy family to point to Little Caesars as the source. So despite both containing puff, the overall impressions were materially different in how consumers would encounter and understand the marks. And on that basis, the similarity factor weighed heavily against the likelihood of confusion.
Yeah, and the case is a great reminder that overlap in a shared element, especially one that's descriptive or weak like puff, is unlikely to carry the day if the dominant element, which is crazy here, really shifts the consumer's takeaway to a well known family brand. So let's talk a little bit more about the genericness analysis, because many brand owners operate in categories where there's descriptive naming pressure. So, Kristine, what do we learn from the Pizza Puff record here?
Well, first, consumer perception rules. A credible survey showing an overwhelming majority of relevant consumers using or understanding the term generically is very powerful. The Seventh Circuit criticized the idea that a double digit minority associating a term with a brand is enough to defeat genericness. So the primary significant test asks what most consumers think, not what the minority thinks. Second, marketplace usage matters. When third parties and even the USPTO's own records show the term repeatedly uses a descriptor, that supports genericness. Courts will look beyond registrations to how language functions in the field, including trade press, menus, product descriptions, and packaging claims.
Yeah, great takeaways, Kristine. We also learned that courts can be quite skeptical when a plaintiff leans on the argument that competitors can use other words so that the plaintiff's term isn't necessary. That really got shot down by the Seventh Circuit. It's just not the test for genericness. The focus needs to be on what consumers would call the good or service. And if the consumers themselves have already adopted the term as the name of the product, trademark law is not going to give one company the ability to fence that term off or monopolize it. Practical note here, brand owners really need to monitor how distributors, retailers, maybe even their own marketing teams use a mark. If your own marketing collateral slides into noun or verb use, or your partners are using your mark as a category name, you can really accelerate the slide towards genericness. So you really need to have brand guidelines and if necessary, issue corrective communications. Those are all critical to protecting borderline terms like pizza puff.
And besides genericness, the Seventh Circuit also nodded to descriptive fair use. The idea here is straightforward. Even if a mark is protectable, others can use the same words descriptively if they're referring to a characteristic of their own goods and not using the term as a source identifier, and doing so fairly and in good faith. So here, even if pizza puff is ultimately protectable, Little Caesars fair use defense provides an independent barrier to the Illinois Tamale Company, showing likelihood of success at the preliminary stage.
And for marketers, that concept of fair use is extremely important. If you're naming a product, you want to avoid stepping into a competitor's distinctive mark, of course. But if the words are truly descriptive of feature, like the size, ingredients, texture, or function, you need to present them in proximity to your own house brand with clear source cues that can mitigate any risk and bolster the fair use position. You also want to document the naming rationale and also emphasize trade dress that for your brand.
Yeah, all very good points. And turning to confusion, the Seventh Circuit's approach will resonate with those who manage house brand families. The court gave real weight to crazy as a dominant source signifier that consumers already associate with Little Caesars. So, in the overall impression, Crazy Puffs tells consumers this is part of the Little Caesars crazy lineup. By contrast, Pizza Puff tells consumers what's inside.
Yeah, it's a good reminder that strength can really reside in the family brand and not just a single mark. Where the defendant's product name, like here, fits seamlessly into a well established family, courts are much more likely to view the overall impression as pointing to that house brand, especially when the shared term here, puff, is weak or descriptive. It really shows the value in investing and consistently using a family naming architecture that really pay dividends in litigation here.
Yeah, so let's translate this into some real world guidance. First, if your core product name leans descriptive, especially in food, beverage, or personal care spaces, assess the risk of genericness early. So you can commission a scientifically rigorous consumer survey before staking major enforcement campaigns on protectability. And if the data shows consumers use the term generically, pivot the strategy. Emphasize your house mark, build secondary branding devices, and educate the market on proper usage.
Yeah, and as we alluded to earlier, you really need to police usage both upstream and downstream. That means your own marketing team, franchisees, retailers, distributors. You want to provide them clear brand guidelines, how to use the mark as an adjective, how to pair it with a generic product noun. A great thing to think about here is what is the product noun for a pizza puff? Like if it was going to be a pizza puff brand something, what would that something be? You also want to make sure you include appropriate trademark symbols so you're signaling to people that it's a brand and avoiding those noun verb uses. You also want to consider registering stylized or composite marks and consider adding design elements that can add distinctiveness to your potentially descriptive mark.
Yeah, another point of guidance when launching new products, leverage your house brand or family marks to anchor source identification. So the Crazy Puffs outcome shows how strong a family can differentiate even when descriptive words overlap. And make sure the house mark is prominent in packaging, menus, and ads and other marketing materials.
And if you do want to use a term to describe your product characteristics or something about your product, and that term overlaps with a competitor's word, you really want to make sure you're framing that usage in a clearly descriptive context alongside your brand.
Yeah, and finally, at the preliminary injunction stage, expect rigorous scrutiny of surveys and marketplace evidence. Plaintiffs should anticipate defendants presenting dictionary definitions, third party usage, and registration records to argue genericness. And defendants should compile that record early, including evidence of their house brand prominence and packaging executions to undercut similarity.
So we can also think about this case from the plaintiff's side. And one lesson is you shouldn't assume your registration alone is going to beat genericness defense at the injunction stage. Certainly it's a benefit to have a registration, no doubt about it, but they can be subject to attack. So you really want to be prepared with up-to-date survey evidence that focuses on the relevant consumer population, as well as having a clean record of your own proper trademark use. If your mark that you're going to assert is close to that generic descriptive line, you might consider narrowing your claims to stylized or composite versions of the mark that better reflect its true distinctiveness. Obviously, I think that strategy was not available to the tamale company here, but in other cases it may be.
Yeah, and for defendants, build the descriptive and genericness record thoroughly. Consumer surveys, dictionary and trade usage, USPTO records showing descriptive use by others, and examples of your own contextual use that looks and feels descriptive, not source identifying. If you have a well-known house brand family, lean into that and identify across the record menus, in-store signage, websites, social media, packaging, and whatnot. So the overall impression analysis clearly points to you.
So let's talk about where this leaves the parties. So Little Caesars can continue to use its Crazy Puffs mark, and the barrier to other parties using Pizza Puff descriptively is much, much lower given the panel's analysis. For the Tamale Company, protecting Pizza Puff as a standalone word mark is just going to be much harder. There still could be further litigation on the merits, but the Seven Circuit's framing of the survey and usage evidence sets a pretty high bar for reversing course.
Yeah, more broadly, this decision underscores the reality that descriptive product naming in crowded food categories is risky if you intend to build exclusive rights. So, anchoring your source identity in a house mark, a distinctive logo, or a consistent family naming structure is often the most durable long term strategy.
Yeah, I also think it's important to think about the resources you're going to be able to put into a descriptive mark. Like maybe a huge company can do it and really try to protect it, but for a smaller company, it's going to be very challenging. So let's wrap up with a couple big lessons. First, the primary significance test, that's what drives genericness. And credible survey evidence and marketplace usage will carry tremendous weight. And second, in a confusion analysis, house brand families can be decisive in shaping how the court assesses the overall commercial impression and can certainly reduce similarity even when descriptive terms overlap.
And for in house teams, now is a good time to review your brand guidelines for potentially descriptive marks, refresh training with sales and retail partners, and audit packaging and menu copy for nouns and verb misuse. If a mark is borderline, consider supplementation with distinctive house marks, taglines, or trade dress that you can actually defend.
So that's it for today's episode of the Upper Brand. If there's other trademark decisions you'd like us to unpack, especially where surveys, fair use, or family of mark strategy are front and center, let us know. Thanks for listening, and we'll see you again next time.